So I'll try and keep this as short as possible because I just want to basically get the point across. You might be aware that there was a Gail Bradbrook case the other day for Extinction Rebellion, but in terms of all the ULEZ cases where anyone's been protesting or doing actions and so forth, right? So I think the judges have been misleading us. I think they've been lying. Now, the reason behind that is this. So with the Ian Bray case at Southwark Crown Court with Judge Gregory Perrins, so the jury gave not guilty verdict, and the judge was saying there's no legal basis at all whatsoever, right? But they just completely ignored that. That actually happened, and they made the order. So, the law didn't apply. But since then, the judges have been saying things to the jury like, oh, there's no legal basis. Don't vote with your conscience, or don't use your conscience. Don't decide with your conscience, right? They've got to follow the law. That's actually not the case. And I think the judges have been perverting the course of justice and actually misleading the juries. Because in this, what we've got up here, I've been doing a lot of research through the acts of petitioning and find out how it was created and formed. And it clearly is legal process. But the thing is that it says here in the 1628, so we're going back to before the Civil War. In the 1628 Act, which this is setting out the whole legal process, right, and defining it, it says, but by lawful judgment of his peers or by the law of the land. It says or by the law of the land. So it's either or. Now, this is what you've got really in a court, because you can have a judge trial only where the judge uses the law. He's meant to decide by the law, or you can have by jury. But the differentiation here is it's by your peers or what the law says. Now, that is not saying that the peers have to use the law. That is an alternative. So that really actually goes down to what the people think. So that in the basis, this actually confirms the basis for what happened in the Ian Bray case. And that means that you can completely if the jury want, they can disregard the law. Now, if the jury can disregard the law, which they did in Ian Bray and actually having a number of cases, then that means that the judge is out of order and out of place by telling them, to not use their conscience or what they think. Particularly when, and this is the big thing, if the jury are supporting the cause or agree with the cause, or have signed petitions for the cause or are supporters of it, right, they can vote on the fact that they support it. They support the cause. They can decide based on the fact that they support the cause, because they don't have to actually decide on what the law says, and it's got nothing to do with your conscience. If you support us of the cause, it's purely on whether you support the cause. Now, the thing is that petitions, when you go and get the signatures of the public, you're getting the public support anyway, a section of the public, so they're already agreeing to what you're doing. And when you get onto the other acts, like the 1661 Act, there's a special procedure through the King's Bench and so forth. And, before Parliament was forming and, so forth, you petition directly to the King and Privy Council, which is outlined through these. And there is meant to be, it's not meant to be dealt with through the local courts. There's meant to be a special procedure. The 1661 bill had petitions going through a grand jury, checked by a grand jury and what you're doing and so forth, you know, or justices. But they scrapped that. They said they're not allowed to anymore in the 1688 bill, and they made it illegal. So what it actually is that the jury actually, in a trial anyway, can disregard the law and don't have to make a decision based on the law. And that means it's not even on the conscience either. It can be on, you know, if they support, if they happen to support something. The jury are meant to be chosen by random. But the thing is that when you're bringing a case to the government by petition, you've already started a legal proceeding. You're already doing one. And when you're getting people to sign it, you're already getting the support of the jury by getting them to sign it. And the thing is, what these cases are injunctions, really. They're really attempting to injunction, but if it's a petition to Parliament, not to like the local council, it's a higher jurisdiction from the start. So all these magistrates' courts cases and Crown Court cases are lower jurisdiction injunctions, which really aren't really lawful, because you've already got, if you've got a large number of signatures of the public, they're already saying that we're giving the approval of what you're doing, which is basically the exact same thing as like the jury in the Ian Bray case. Now, the technical part of it, you know, in the court is that the judge, according to this 1628 petition of right, it doesn't have to be by what the law says. It can be purely on what the jury think, if they do, you know, have conscience, or even if they support it. This is why you're meant to have a jury picked out at random. But the fact is that with the petition, you are bringing a case to the government yourself. It's not like, you know, you've been out doing random crime. You've raised the case. Now, I didn't really I wanted to try and keep this as short as possible, particularly like 5 minutes, but it's going to be like about 10 minutes by the looks of it now. Where this is significant, though, where this really, really is, I think that I don't think that the Blade Runners can be prosecuted, because theoretically, if they get into court, right, the judges are trying, if you get trial by jury, and if you happen to get, like, you know, ULEZ supporters in the jury, they can find them not guilty, the Blade Runners. Now, the thing is, the judge, if they're ULEZ supporters, they can make their verdict purely on the fact that they support it. They don't have to actually, according to this legislation in front of me, it says that they don't have to judge it by the law. They can judge it by their own opinion of the people. It doesn't matter whether they've got conscience or not, if they support the cause. So it can become purely on supporters of the cause. Now, that is why in the Civil War, when you had the Royalists and Roundheads and a lot of fighting and lots of courts taking different sides and juries, that is why you had a lot of, unfair cases. So that's why they made it illegal. So, because you got supporters of either side and you weren't getting fair trials either way. So, but the thing is, if you're doing a petition and you're already collecting massive numbers of public support, you're already getting your actions approved by the jury. So, if the Blade Runners are taking cameras down and the public, at least a significant amount of the public are supporting it and condone it, then according to this, if a section of the public think that it's okay to do it, then they're not breaking the law. And if they've got that in writing in their case to the government as part of the petition supporting it, that is your public support. That is your peer support. So it's kind of like overriding the law by the public condoning it. Now, even if the petition itself is not accepted as evidence of that case and of the support, in a court situation with the Blade Runners, if there happen to be ULEZ supporters in the jury, they can make the decision according to this. They can decide purely on whether they support it or not, and the law actually doesn't matter at all. So I challenge the Met Police, and I challenge Rowley. I challenge him because he's just been on with Maya Tusi, on the programme. They've had the chief on. I challenge Mark Rowley that Blade Runners can be found not guilty by jury, and the judge got no place to tell them how to make the verdict, whether there's a legal defence or not. And when it doesn't have to be on where there's a legal argument or not, purely whether they support it or not, well, that confirms that the basis for the right to petition and people supporting it and signing it and exemption from prosecution. It says in the 1689 claim of right that you can't be imprisoned, and when it comes down to community service as a punishment, it's good causes. You can have your community service written off by hours you've done for good causes and charitable causes. Now, if people are donating to these campaigns and they're a good and charitable cause, and all the things that they've done for it writes it off. So it's almost like sealing a complete circle. I think that they're covered. And this is what I think. I think they are covered, and I think that that Ian Bray case is a very, very good example, and it just shows that the signatures on the petition case that's your legal document, that's your weight. If you get challenged by the police, right, and you pull out, all the signatures on the bit of paper supporting what you're doing, that effectively is your license to do it without being liable to be criminally prosecuted. So I just want people to think about that. It's the 1628 Petition of Right, and this is like the very, very foundations of trial by jury and so forth, which they meant to really have in civil cases as well. So,